Security stakeholders have poked holes into the Kenya Defence Forces Amendment Bill 2015, saying some clauses aim at reducing accountability measures by Parliament over the Defence Forces, undermines the role of Parliament in deployment of military and overstretches the role of KDF in internal security matters. Appearing before the National Assembly Committee on Defence and Foreign Relations, security stakeholders faulted the bill, which seeks to extend the term of the office of the Chief of Defence Forces and Vice Chief of Defence Forces and service commanders, arguing that doing so would mean forced early retirement of about 18 senior officers who would have otherwise been promoted to their next ranks at the expense of one person. Retired Lieutenant Colonel Robert Kibesu told the committee that the proposed extensions of terms by the President will increase the control of the executive arm of government, which may affect the operations of KDF.
The effect of performance of duties will be based on how he responds, which becomes now political as opposed to the professional duty he is supposed to perform. He'll be more concerned about how do I get an extension as opposed to performing and giving the requirement.
Kibesu also want clauses 19 and 20 of the bill, which gives KDF the jurisdiction to draft any legislation for the establishment of a courts-martial as a subordinate court under the judiciary, deleted, saying the establishment of the courts-martial in the KDF Act 2012 is an affront to the Constitution.
We cannot have a court-martial which is an ad hoc court, but it must be a standing court established to be able to meet the ends of justice. And members of the KDF are greatly prejudiced by not having a standing court which is impartial. The requirements of Article 50, that one must have fair trial.
The stakeholders have rejected the bill proposal to introduce the creation of an auxiliary reserve force consisting of the National Youth Service, the Kenya Wildlife Service and the Kenya Forest Service, saying they don't constitute security organs and are not properly trained to carry out work meant for the KDF.
They have not been trained on how to deal with insecurity. They have not been trained on what constitutes critical national infrastructure and how it requires to be defended. These are skills that are only with the KDF.
Most of them are headed by civilians with no basic military experience nor training. It would need time and resource to train such employees of this institution to convert them to military profession.
They also want clauses 15, which seeks to delete sections 33 of the Act, which places the Inspector General of Police as the person in command and controls of security operations, deleted, saying it lacks clarity as to who will be in charge when security operations are being carried out.
On who should be in charge of the Kenya Police when they have been deployed to such operations. It should be clear, and this will avoid confusion amongst different security organs who are in such operations. And our proposal is that, as previously or as it has been under the section 33.3, then the Inspector General should be answerable.
Now, the bill also removes the requirement that the Defence Cabinet Secretary's annual report include itemized statements on utilization of public funds.
Somalwa, MP Kiminini, member of the